Good afternoon, everyone. I am Ipshita Bhattacharya, and today, on behalf of the trademark and copyright team at BananaIP Councils, I have come up with a case recently decided in the Delhi High Court with regards to the trademark. The case that we have today is Vasundhra Jewellers Private Limited versus Vinodbhai Jadvani. The case was decided on 21st of September 2022. And it is very relevant for us as it decides on the basis of deceptive similarity between two device marks with similar text and the significance of it in present context of trademark jurisprudence. So the plaintiff that we have today is Vasundhra Jewellers Private Limited, and they have been involved in the business of jewelry making. So they have high-end jewelry that they have been selling and manufacturing and designing since the early 90s. And they have been using the mark Vasundhra since 1st of January 1999. And they have three device marks, as we can see, Vasundhra, the label V, and the label V with the mark Vasundhra Jewellers. All of them registered as device marks in class 14 and have been used since earliest is 1999 and since the latest the V mark has been used since 2016. So along with this, they also have 7 different domain names registered to themselves called Vasundhra Jewellers, Vasundhra.com, Vasundhara.com, Vasundhra.in, VasundhraJewellers.in, VasundhraJewellers.com, and VasundhraJewellers.in. The defendant that we have is Vinodbhai Jadvani, and they have one mark registered in class 25 as Vasundhra Fashions, and it has been in use since 2nd of December 2020. And they have a domain name registered under the name vasundhra.business.site. Now, they have registered for a label mark, again, device mark, with the picture of a coconut tree leaf with Vasundhra Fashion written in it. However, their physical store, which is in Gujarat, has a different kind of a mark on their stores. They also have business that they conduct through different e-retail stores like Flipkart, IndiaMart, Shopzee, Meesho. And the mark that they use in the store is Vasundhra, not Vasundhra Fashion, as they have registered for it. Now, the contentions that we find here is that the proprietors of Vasundhra Jewellers, the plaintiffs in this case, they say that they are the prior registered users of the mark Vasundhra with the same spelling as the defendant is using, and they have recognizable goodwill because they had done recent shoots for high fashion jewelry, including big names like Janhvi Kapoor. Now, they allege that the marks are deceptively similar, and because clothing and jewelry, the defendant are in the business of clothing only. So because clothing and jewelry are very aligned to the fashion industry, and therefore these goods are considered to be and can be considered to be allied and cognate goods. And although all the three marks registered by Vasundhra Jewellers are device marks, along with the websites and domain names that they have, the essential feature of their device mark is the word Vasundhra. That's the recognizable element common throughout all their marks and the branding that they use. Therefore, the use by defendants of the words Vasundhra leads to infringement, passing off, dilution of their mark, and creates an unfair competition between the both the proprietors, especially the marks in the fashion industry. Now, they had said, the plaintiff in their contentions, that they have no objection if the area of operation of the defendant is just limited to Gujarat on a business-to-business model instead of going cross-border through their e-retail stores or going for an all-India shipping and delivery. Now here, the defendants contend that class 14, in which the plaintiffs are registered, and class 25, in which the defendants are registered, are very different classes of goods. They might be related to the fashion industry, but did not necessarily relate to the same customer base or same strata of the society. The defendants allege that high fashion jewelry is something only a few people with access to that kind of wealth can use or even buy. However, the clothes that they sell are in a very different price range, where the highest price of their clothing go up to 1,000 rupees. Furthermore, their business is mostly a business to business model, mostly confined to state of Gujarat, meaning that 80% of their work happens to be supplying clothes to other businesses within Gujarat. Only 20% of the business is done through e-commerce for pan-India customers. That too for clothes which are below the range of 1,000 mostly. The other contention that the defendants put out is that the plaintiff has a single shop in Pitampura, New Delhi, which does not even have a pan-India reputation. They're a local shop in New Delhi, known in New Delhi, and their allegation that they are working with high fashion houses and celebrities is false, because the advertisement that they are putting out for their jewelry is basically a fashion ad by a fashion designer in which their jewelry was used. It was not an ad for their jewelry per se, or a sponsorship of their jewelry, just something that the model Janvi Kapoor had to be wearing while doing the shoot. Also, they contend that the name Vasundhra is a very common name in India. Given the fact that there could not be any exclusivity over a name which is very common in India, and it cannot be contended to be an essential feature, given how commonly people relate to it across different states in India. Furthermore, that they have mentioned that the defendant's mark is for a different class, whereas the plaintiff's mark is for registration in class 14, and also as device marks, where they have not claimed any specific rights over the word mark, the literal element that is Vasundhara. So with these contentions, the Delhi High Court under Justice Navin Chawla had given the judgment that, keeping in mind that plaintiff's mark, all the marks are all device marks, and there has never been an exclusive claim over the word Vasundhara, and given how trademark jurisprudence has been and how it is decided that you have to exercise exclusive right over a mark only when it's as a whole, and one part cannot be claimed by dissecting the entire mark to be the essential feature. Furthermore, Vasundhara is a common name in India. It is not descriptive of the goods either for plaintiff or for defendant. In that context, Vasundhara is almost an arbitrary use of a common name for the goods that both plaintiff and defendants are selling. Also, the goods that are sold by plaintiff and defendant are very different. They exist in different classes of the trademark registry. They also cater to different classes of the society. Furthermore, given that both the marks are device marks, there are visual differences between the conflicting marks. So visually, when perceived by a person will not mistake the plaintiff's mark to be the defendant's mark or the defendant's mark to be the plaintiff's marks. Also, the area of operation for both the businesses are different, and both the proprietors have different channels of trade, different channels through which they conduct their business. So taking into consideration all of these pointers, also referring to the case of Register of Trademarks versus Ashok Chandra Rakshit and South India Beverages versus General Mills Marketing India, the Honorable Justice Chawla has observed that though it is equally well settled that for a device mark, the essential feature of the same is equally entitled protection, at the same time, it has to be remembered that in extending such protection, the party does not lay claim of exclusivity in a mark to which otherwise he would have been unable to do so. The possibility of the proprietor attempting to expand the operation of this trade cannot be ignored or overlooked. Keeping this observation in mind, the case was decided in favor of the defendant, Kirai Vinodbhai Jadvani, stating that mere similarity in literal element of device marks is not enough if there are visual and other differences in terms of mode of operation, areas of operations, the trade channels, and the customers catered to, and the geographical area that is within the sale of business. In keeping these factors in mind, a decision can be made to allow registration of two similar literal elements of device marks in different classes. So it is very relevant for us who are defending examination reports with a section 11 objections by the examiner. This case becomes very helpful and handy in those regards. So I felt it was very relevant for us to discuss this today. With this, I thank everyone. Sign off for today. Thank you.